Okay, we're going to move on to questions to the Minister for Justice. May I call Colin McGrath?
My concerns about the Northern Ireland Troubles Legacy and Reconciliation Act 2023, which marked a significant departure from the Stormont House Agreement, blocked access to justice for many people and caused distress and anxiety for many. I am not surprised by the Chief Constable's comment that legacy issues contribute to an individual's decision to apply to join the police service, amongst a wide range of other considerations. It's important that our police service is reflective of the communities that it serves, not just in respect of religious make-up, but also in terms of other characteristics such as gender, ethnicity, disability, sexual orientation and so on. When communities can see themselves represented in their police service, trust and confidence in policing grows stronger. I am confident that there is an appropriate legislative framework in place to encourage applications from all underrepresented groups, and would emphasise once again that it is incumbent on us all, as elected representatives, to encourage all members of our community to consider joining the PSNI and to help create the societal conditions where that is the most likely to occur.
Mr McGrath.
Thank you, Mr Speaker. Can the Minister confirm if she agrees with the evidence of the former Police Ombudsman Nuala O'Loan to the current Northern Ireland Affairs Committee legacy inquiry that, quote, what is required at this stage is a new legacy institution? And does the Minister also agree that there must be an independent public inquiry into the murder of Sean Brown?
Well, there are two separate issues. First of all, with respect to the Ombudsman, obviously the Ombudsman is entitled to set out her own views, but I have been clear that a patch and repair job with respect to the ICRIR is not the way forward. I don't believe that that will build the confidence within the community that we need to see. I know the UK Government, however, are committed to continuing with that structure, but reforming it significantly, and so there is somewhat of a divergence in our views. With respect to the Sean Brown inquest, you will be aware that the matter is before the courts. That is a matter for the Secretary of State and for the NIO, and it would be inappropriate for me to comment on matters that are before the courts currently. However, I would say that my thoughts are with the family of Sean Brown and with other families who continue to seek to have truth and accountability around the deaths of their loved ones and have so far been unable to achieve it.
Robert Clark.
Much, Mr Speaker, and take the Minister back to the original question in terms of the legacy, in terms of trust and rebuilding trust and confidence in policing. And I would also like to concur with her remarks in supporting people from all sections of the community to continue to apply to join the police. However, in the Chief Constable's comments, obviously there's a financial pressure that greater than no other in terms of policing. So can I ask what representation you have made to the Treasury themselves directly in terms of this legacy piece to see if we can come to a conclusion in terms of the funding that can support the police to allow them actually to rebuild trust and confidence in other areas?
Minister.
Well, as you will be aware, representation on behalf of the Executive to Treasury doesn't happen through each individual department, it happens through the Department of Finance, but the case has been made by the Department of Finance on behalf of the Executive. The additional resources needed. I have personally raised the issue of legacy, both with the Prime Minister when I met him previously, and also with the Secretary of State on an ongoing basis, because it is clear that the modern justice system in Northern Ireland, the contemporary justice system on which we rely today, is not properly resourced, funded or equipped in order to deal with the ongoing burden of legacy, and that takes a toll both on the morale and the capacity of our current organisations. It has an impact whether that be on the Ombudsman's Office, the Police Service of Northern Ireland, the court system or any other part of the system, and that is not in any way to diminish the rights of the victims who need to get access to that information and to justice and to truth. But it is to say that the UK Government, as that body responsible for legacy, ought to be properly funding it within our system.
Mr
Speaker, and to the Minister as well. Minister, would you agree that the ongoing debacle and treatment of Sean Brown's family regarding his case is also presenting significant barriers, not just in terms of trust and confidence in policing, but the wider criminal justice system?
Minister.
Well, I think that any legacy issue which is contested in the public space will have an impact on people's views of the contemporaneous justice system. That is an inevitability that is unavoidable. I think, however, it's important to note that the decisions around this have been made by the Secretary of State, and that it wouldn't be, I think, appropriate for me to provide any assessment in terms of the Court of Appeal judgment, because that is a matter for the UK Government and it is subject to ongoing legal proceedings, and I don't want to dip into that space as it would be inappropriate. But I am very aware of the hurt and disappointment felt not just by the Brown family but those who support his family in their calls. I would offer them my heartfelt sympathy. They are continuing to seek answers about what happened to their loved one, as so many families do, and as so many families have been frustrated in doing over recent years. I hope that soon that will come to an end.
Peter McReynolds.
Minister, what is your assessment on the extent to which the PSNI's requirement to deal with legacy investigations impacts upon the delivery of contemporary policing and justice priorities?
Minister.
Well, I think there are a number of issues here. I mean, obviously the devolved justice system was never properly resourced for legacy matters. When justice was devolved in 2011, all of the liabilities that related to the ministers who held office prior to that were devolved to Northern Ireland, but no one anticipated at that time that we would be standing here in 2025 with the matters of legacy unresolved. And so the lack of a proper funding package for legacy investigations undoubtedly impacts trust and confidence in policing. It impacts the capacity of policing to deal with contemporary issues, but it also diminishes the confidence of sections of our community in policing to be able to respond to those historic issues. And by the constant association of our contemporary justice system with what went before, I think that there is a danger that we lose sight of the extensive reforms that have happened within all of our justice system during the last 15 and beyond years beyond. I also think that, from my perspective, the resource is probably the biggest challenge that we have. I mean, obviously, the organisations for which my department has responsibility will continue to comply fully with their statutory obligations, but it has to be acknowledged that even if the ICRIR takes over and is in place and is human rights compliant and all of the other things that the government say they intend it to be, there will still be a burden on the justice system, both from those cases which lie outside the strict legal definitions for the ICRIR, but also in servicing the ICRIR in terms of disclosure.
Sinead McLaughlin.
Number 2.
Minister.
The legal framework governing the rights of parents and children vests in the Department of Finance rather than in my department. My department is responsible for the operation of the justice system and courts. I am committed to taking whatever steps I can to improve the operation of the family justice system, and I'm continuing to prioritise action to improve outcomes and the experience of families involved. Together with the Minister of Health, I'm continuing to develop tools under the Private Law Early Resolution Action Plan to support parents to resolve disputes outside the adversarial court environment and to aid the earlier resolution of disputes which do come before the courts. I'm also taking steps under my recently announced Enabling Access to Justice programme to ensure we're effectively supporting the most vulnerable and using resources to best effect. That includes revisiting eligibility and merits tests for the provision of legal aid to ensure resources focused on greatest need and risk of harm. It also includes introducing bespoke delivery models to provide specialist tailored support and advice to vulnerable groups, including victims of domestic abuse involved in family proceedings. Scoping work is also in train to consider the potential to increase the transparency of family courts, whilst ensuring safeguards are in place to protect the privacy of the children and families involved. I recently discussed this matter with the Lady Chief Justice. Her office is giving the matter further consideration, and I hope to be in a position to advise us to next steps in the near future.
Longland.
Thank you, Minister, for that answer. Women in particular and families are going through the family courts and they feel that the operation of the system itself is actually failing them. The work that you've outlined is really useful, and the avenues regarding the exploring of the scoping exercise, the fact that it's underway, is also really helpful. But I'm just wondering, have you any practical suggestions that we could explore, that families could get help more urgently at this time? You know, is it committing additional funding to support those going through the system would also be helpful? Is any of this in your to-do list?
Well, in terms of additional funding, we have set aside additional funding for legal aid in years. So those who are seeking general advice and also who are seeking legal representation where they are enabled and entitled to legal aid should be able to do so more readily. As you will be aware, we also in the last mandate included a waiver for domestic abuse, which was to allow those engaged in family proceedings who had been victims of domestic abuse to have the monetary test for legal aid actually waived in order that they could access it. That has not been the success that we had hoped and does not seem to be as regularly used as we would wish. And one of the reasons for that seems to be the complexity of the application process, so that is something which we're also looking at in terms of simplifying it. Decisions obviously in individual cases are and will remain a matter for the independent judiciary, but any party concerned about the outcome or handling of their case can seek legal advice as to whether or not there are grounds for appeal. There have also been complaints made to me regarding social workers, but those are a matter for the Department of Health, who are responsible for matters relating to their training and regulation.
Minister, what more can your department do to address the lack of children's court guardians impacting on children in the family court system?
I'm aware that the absence of guardians ad litem or children's court guardians has been a significant issue in terms of slowing down access to justice. But if there are specific areas or issues which the member is aware of that she wants to bring to my attention, I'd be more than happy to meet her to discuss it further.
If I may, I'd like to direct the Minister to discuss the domestic abuse space. At present, we're getting significant complaints from those who have been victims of domestic abuse that the non-molestation orders are not as effective as they may be, and that the perpetrators are perpetually in breach of same. Could I ask the Minister if she would, in light of the delay given to prevention orders and notices, what scope has she undertaken to establish the effectiveness of non-molestation orders, and whether anything could be changed to help them be better?
The member's frustration, but non-molestation orders are a matter for the Department of Finance and not for the Department of Justice. Enforcement in individual cases is a matter for the relevant judge, and in reaching decisions, the judge will strive to ensure the paramount consideration of the welfare of the child is not compromised. Breach of a residence or contact order can readily be dealt with through contempt of court proceedings or a summons initiated under General Enforcement Powers in Article 112 of the Magistrates' Courts Northern Ireland Order 1981, which gives the court the power to fine or imprison. However, the best outcomes for children will be achieved if parents avoid the type of acrimonious dispute and entrenched relationship difficulties that can lead to the breakdown in contact and residence arrangements in the first place. That is not, however, possible in cases such as the member referred to, where domestic abuse has played a role, and therefore it is important that we look forward to the DAPOs and DAPINs and the work that my department has been doing along with PSNI colleagues to scope out how the trials of those are operating in England and Wales. You'll be aware of the considerable concerns the PSNI had expressed prior to us going live with that legislation here, and we are now working with our counterparts in England and Wales in order to better understand how they're going about implementing and the structures around that, to see if there is something that we can do in that space that may be more useful perhaps than an NMO.
Egan.
Thank you, Minister. I've been contacted by many parents who have concerns around how the family court system operates. So could I ask what steps your department is doing to make the family courts more transparent?
Well, I think one of the key things for me is that transparency within the justice system, and particularly within the family courts, has to be balanced against the issue of the private and personal information often related to minors that could be disclosed. So we are looking at this issue, and I think the member will be aware of the work that my department has been doing in that regard. However, it's important that we understand the consequences in terms of the legal system and the consequences in terms of individual privacy. We've been following developments in relation to England and Wales, who have a reporting pilot into family courts, and will continue to monitor that. We are looking more widely at the reporting of family cases, because the Gillen Review and the Shadow Family Justice Board both proposed this, but in both cases it was very contentious. There are very strongly held and differing views on this issue on both sides, so there will need to be detailed consideration. However, I believe that people's understanding of our court system would be enhanced considerably if people were able to, at a minimum, be able to see transcripts, even if those were redacted, so that the individuals in them could not be identified, in order to better understand the considerations that the court makes in reaching its conclusions.
Danny Becker.
It's number 3.
Investigation into complaints of the police are an operational matter for the Police Ombudsman for Northern Ireland. However, I recognise the potential for abuse of position, including sexual exploitation by persons in authority when engaging with vulnerable persons. I therefore support the direction of travel by the Office of the Ombudsman to develop and take forward a work plan aligning with the key PFG objective to combat violence against women and girls. As part of my consideration of the APONI 2025-26 business plan, I will be giving careful deliberations to those robust and effective processes to ensure they're in place to have accountability and safeguarding.
Baker.
Thank you for your answer, Minister. A recent CGI inspection report noted that as of July 24, the Police Ombudsman's Office had 19 active investigations of abuse of position for sexual purposes. Does the Minister plan to introduce a more comprehensive vetting process and a code of conduct?
Sure.
Well, the vetting of police officers and the employment of police officers is not a matter for the Department of Justice. However, when you look to the Sagini report, abusive position concerns and complaints, there are recommendations on how justice organisations should address matters and the timeframes within which they should do so. PSNI, APONI and PPS all have responsibilities in addressing the abuse of position that was referenced. Given that those organisations are operationally independent, for me as Justice Minister, my department, I can't comment on the progress of their recommendations. However, I do agree that it is important that robust and effective processes are in place to ensure accountability and safeguarding. We're certainly supportive of engagement on this issue, and if found to be appropriate, we consider what steps could be taken to improve outcomes, particularly given that the Ombudsman's investigations around abuse of position of trust is in relation to abuse of position for sexual purposes. Given the vulnerability of some of the people in contact with the police, it is important that we have absolute confidence that those individuals involved in that unethical behaviour do not draw other ethical officers into disrepute.
Gillian McAllister.
I thank the Minister for her answers so far. Minister, as a member of the Northern Ireland Police and Boards Performance Committee, we often do look at the police officer misconduct that falls under the Professional Standards Department, and we are aware that there are some issues with the processes into that. I just want to ask the Minister if you could provide an update on your department's review of the police officer misconduct process.
Minister.
Well, my department is currently exploring a number of legislative proposals in relation to police officer misconduct. Members will be aware that APONI in their 5-year review brought forward a number of recommendations, and indeed there were a number brought forward from the PSNI themselves, I think 7 in all, in relation to misconduct. Should primary legislative change be required, it may not be able to progress in this mandate given the other legislative pressures. However, whether primary or secondary, that will be subject to a statutory consultation process. It is anticipated that a targeted stakeholder consultation will be initiated within the coming months to look at some of the options that we are considering in the department for making a more robust investment in terms of professional standards. It is also to be said that it is not just about vetting, because I think the member previously had raised the issue of vetting, which I didn't answer. It's not just about vetting people who, when they apply to move into the PSNI, are vetted in advance. It is also about internal vetting, where information that may have come to light about an officer's conduct or behaviour while he is a member of the PSNI should be considered very carefully if he is moving into sensitive roles and if she is moving into sensitive roles which could in any way create some conflict or concern.
Thank you, Mr.
Speaker. Would the Minister be in a position to outline the number of cases of abuse of position for sexual purposes that have been investigated in the last 12 months compared to the previous 12 months?
Minister.
It wouldn't be possible for me to do that because I wouldn't have access to that information directly. However, since 2021, APONI has advised me that they have received around 40 complaints of what they described as police predatory behaviour, and say that they continue to receive an average of 8 cases per year. So they have not suggested that that has significantly increased, but there has certainly been a steady flow.
John Blair.
Mr. Speaker, question number 5.
Mr.
A late guilty plea can cause particular challenges for victims, witnesses and the justice system. Victims and witnesses will have experienced the considerable stress of anticipating and preparing themselves for a court trial that does not then proceed or does not proceed to its conclusion because of the late change of plea. Seeing sentences reduced following a guilty plea can also lead to a sense of injustice and loss of confidence in the court system. For the justice system, which will have seen a lot of police, prosecution and court time taken up by investigation, case preparation and court scheduling, additional costs will be incurred which could have been avoided if an earlier guilty plea was entered. One of my key aims as Minister of Justice is to drive consistent improvement in the Northern Ireland justice system. With this aim in mind, I've recently published a consultation to seek views on the way in which the criminal justice system in Northern Ireland deals with reductions in sentence length when a plea of guilty is entered, to hear a range of views from the public and stakeholders on what is a critical issue.
Mr Blair.
Thank you, Mr Speaker, and thank the Minister for that answer and outlining the pathway that is required. Can I ask then, in addition to that, what action she as Minister or the Department are taking to address these challenges?
Minister.
The consultation that I referred to will close on the 11th of July, and after that the Department will then carefully consider all of the responses received. I don't think it would be appropriate to predetermine the potential policy solutions that may be introduced until those responses to the consultation have been considered, and it shouldn't be assumed the consultation will automatically result in decisions to change legislation, but it would be fair to say that I am open to doing so. The timing of the consultation has been chosen so that, should change be required and should the Assembly and Executive be minded, there may be an opportunity to progress this as part of the sentencing bill, which is due for introduction in the autumn. That, as you will appreciate, is a challenging timetable. However, with the assistance of Executive and with the Committee's support, I believe that it is entirely achievable.
Matthew Till.
Thank you, Mr Speaker. Someone who changed their plea from not guilty to guilty was, of course, Mr Winston, aka Winky Irvine. Public confidence in the justice system has been damaged by the reduced tariff given to Mr Irvine after letters from apparently the great and the good for work, quote, for peace and charity in the community. Minister, what actions will you specifically be taking? First of all, do you agree that that has damaged confidence in the justice system? And what specific actions will you be taking to review the sentencing rules to improve public confidence after these events?
Well, there is no suggestion.
Note, Minister, something which you brought up the last time about people asking for your opinions continues to happen today. But anyway, I leave it in your hands.
Well, as the Speaker knows, I'm full of opinions, but not always willing to share them in this setting. Members will be aware that sentencing decisions are determined by the independent judiciary and based on individual circumstances for each case. The relevant sentencing guidance is available, and the sentence maximum for the offence in question was specified in legislation. And if you read the issued statement by the PPS, they set out the issues around exceptional derogation from that. So all of this is in line with how the courts operate. I don't direct how sentencing is done, only what the maxima are in terms of certain points in legislation. However, more widely, it is wholly inappropriate for members to ask me to comment on sentences in individual cases. To do so is to invite me to interfere in due process, and that is an egregious breach of the firewalls that exist between the political and the judicial spheres. Where a sentence is considered unduly lenient, the Director of Public Prosecutions can refer an eligible case to the Court of Appeal for consideration within 28 days. As the Public Prosecutor has indicated they are considering that, this case remains sub judice, and therefore I don't intend to comment further.
Doug Beattie.
Thank you, Mr. Speaker. Minister, I've already completed the consultation on sentence reduction for guilty pleas, but can I ask the Minister to outline the benefits of a late guilty plea receiving up to 25% reduction in their sentence?
Well, it isn't for me to set that out. That was a judgment made in the courts in a challenge that was taken as to the difference between an early and a late guilty plea. So initially the range available to the judiciary was much greater, starting at 33% for what would be considered an early guilty plea and down to 0 if they felt it was sufficiently late that it didn't merit consideration. That was challenged and now the courts have said that 25 is around the minimum established. From my perspective, it's not about whether or not I think that that is the appropriate level. My issue is about how transparent and open and credible that system is. And therefore, for me, it is about suggesting and testing the water through consultation as to whether, for example, a clear sliding scale against when guilty pleas are entered should be made, so that it is clear what the importance of the guilty plea will be and how that will factor. It also has to be said that it's not only about early and late guilty pleas. It's also about the definition of early. What is early for the court may not be early for the police or the victim or the public prosecutor or the court system. So it may be the first opportunity somebody has to plead in open court at the start of the trial, but it may not have been the first opportunity they had to plead guilty, which would have saved a lot of people a lot of work and time.
Linda Dillon.
Question number 6.
With your permission, Mr Speaker, I want to answer questions 6 and 11 together. I received executive approval to the proposed content of my sentencing bill on the 19th of December 2024. The bill will deliver on a number of the recommendations arising from my department's public consultation on a review of sentencing policy. It will also make provision for Charlotte's Law, introducing measures to encourage disclosure of the location of victims' remains in no-body murder cases, and will introduce a statutory aggravator model for hate crime offences. My officials are engaged with the Office of Legislative Counsel, and the process of drafting the provisions for the bill is underway. It is intended that bill will be introduced to the Assembly before the end of 2025.
Ms Dillon.
Thank the Minister for that answer, and I'm glad to hear that the sentencing bill will finally be coming before this House. I think it's really important. Can you give us some sense of what is going to be included in that? And I'm really happy to hear about Charlotte's Law being included, but what else in terms of violence against women and girls? Because we've seen some of the recent sentences and they've been nothing short of absolutely disgraceful for serious crimes against women and girls.
Well, again, I don't want to give opinions on sentencing around women and girls. I can tell you what will and won't be in the bill. However, there will be a statement of the principles and purposes of sentencing, provision to allow further use of community sentences, statutory starting points for life sentence tariff calculation, expansion and simplification of the current unduly lenient sentence referral provisions, creation of a new offence of assaulting those providing service to the public or performing a public duty, creation of a statutory aggravator for vulnerable victims, and increasing maximum penalties for offences causing death by dangerous driving. There will also be measures to encourage the disclosure of the location of victims' remains, to which I referred earlier, which will be known as Charlotte's Law, and provision of a statutory aggravator for hate crimes. However, this is based on the 2016-17 review of sentencing, and considerable work has gone into getting the proposals for legislation in place. I do, however, plan to also launch in tandem a further review of sentencing, which may pick up on some of the issues that the member has raised.
Owen Tennyson.
Thank you, Mr Speaker, and thank you, Minister, for those answers so far. Minister, can I ask you to elaborate and provide an update on that proposed review into further sentencing issues?
Thank you. My department is planning a review of further sentencing issues which have emerged in recent years, and particularly those which have emerged since we went through quite a significant piece of legislative change in the last mandate with domestic abuse and sexual violence. Several issues have been identified at this stage for consideration, including the use of character references, particularly in domestic and sexual violence trials, sentencing for serious sexual offences, sentencing guideline mechanisms, and sentences for drug offences. The review will also consider recommendations arising from the recent review of sentencing in England and Wales, and will hopefully lead to a further sentencing bill at some point in the future.
Philip Brett.
Speaker, the Minister will be aware of my, and I believe the public support for the introduction of Harper's Law here in Northern Ireland, which would require a mandatory life sentence for those convicted of killing a frontline officer, be that through murder or through manslaughter. The Minister had told me in a written answer last summer that she had asked her officials to look at this when scrubbing out this bill. Would she have an update for the House this afternoon?
Minister.
Well, the first thing to say is that every person who is guilty of manslaughter or murder receives a mandatory life sentence. The issue is the length of tariff that is attached to that before they can be considered for parole. We do not, in Northern Ireland, for good reason, have whole life sentences, which is, I think, the model that some are looking for in terms of this issue. The department has looked at the issue, and I'd be more than happy to meet with the member to discuss in more detail. I have some sympathy, I have to say, with the concerns that people have, because when you attack, either fatally or otherwise, someone who is providing a public service, such as a police officer, you're not only attacking that police officer, you are also attacking the community which they're there to protect and serve. And therefore it's important we recognise the impact on the wider community when such events take place.
Eva Brooks. Minister.
I'm aware of ongoing issues around the illegal use of off-road motorcycles. Issues such as this, as with any community safety issue, require collective partnership working across local and central government to identify the causes and put in place joined-up long-term solutions to prevent incidents arising and to tackle the cumulative impact that it has on individuals and communities. My department spent considerable resource on awareness raising and supporting a bespoke motorcycle awareness programme, which my department part-funded along with the Department for Communities from 2018 to 2023. Due to the constrained financial position imposed on my department, it was not possible to continue this funding, although both PSNI and councils were encouraged to continue the programme with further programmes organised by PSNI who had secured funding from other sources. Some of the initiatives used to tackle this include the use of education and awareness raising by police and community safety partnerships, jointly funded by my department and the Northern Ireland Policing Board, which includes engagement by community safety wardens in some areas who actively work with the PSNI local neighbourhood teams to tackle the issue. To help address spontaneous and mobile nature of street scrambling, PSNI have advised that local response officers work closely with the Air Support Unit to help tackle the issue. It is a matter that also engages the interests of the Department of Infrastructure as the department responsible for road safety and DFC who lead on sport.
Moving to topical questions, Justin McNulty.
Minister, many people here have expressed concern and outrage at the number of people across the UK and Ireland who have been arrested for protesting peacefully in support of the besieged people of Palestine. What reassurance can you give to people here that they will not be arrested or prosecuted for speaking out against a genocide?
Peaceful protests are an important part of our civil rights. If any person considers that the actions or behaviours of the PSNI when policing peaceful protests are inappropriate, they can lodge a complaint with the Office of the Police Ombudsman for Northern Ireland. However, the policing of demonstrations is clearly an operational matter for the PSNI and they are accountable to the Northern Ireland Policing Board. I am committed to respecting their operational independence, both of the Board and the PSNI, and it would not be appropriate for me to comment. I do feel, however, it is appropriate to say that there is, of course, no law against peaceful protest, but where that protest crosses a line, or where someone is resistant in terms of their engagement with the PSNI, they may breach other laws that have nothing to do with free assembly and free speech.
Just before I call Mr McNulty, over the course of the past few weeks, there has been an increasing from members that they're asking questions about police operations and about how police conduct themselves. There's a place to do that, that's called the Policing Board. You use your members in the Policing Board to do that. This is not the place to be questioning police decisions on the ground at any particular time, and it's not appropriate really to ask the Minister to give her views on those matters, because the Minister can't give her views on those matters. It's as simple as that, and she quite rightly has refused to do that. So I'll call you again, Mr McNulty, for your follow-up question, but I really do caution you as to bringing this type of thing to the floor.
The Minister is at liberty to give her views on, or no views on, the erection of illegal billboards by the main party in government here, whereas she's not able to give a view on peaceful protest against genocide. I find that quite extraordinary. More than 55,000 people have been slaughtered by the State of Israel. Children and women and children are being murdered on a daily basis.
I have a question, Mr McNulty.
It's been live streamed in our homes on a daily basis. Genocide has been live streamed in our homes on a daily basis.
Mr McNulty.
What is the Minister's assessment? What is the Minister's assessment of the reality that peaceful protests...
The member will resume his seat. Stephen Dunn.
I've had many troubling conversations with people who are all saying the same thing. The rule of law must apply and be seen to apply and apply equally. Those aren't my words, Mr. Speaker, but that thinly veiled criticism of the Justice Minister comes from the MP for Lagan Valley, Saoirse Eastwood. Minister, Saoirse's right, isn't she?
Well, I could say Saoirse's always right, and that would save me answering the question, because of course she is. But there's no thinly veiled criticism of me as Justice Minister in Saoirse's comments. I think I could stand here too and say that the law must apply and be seen to apply equally to all, and that is why I do the role I do, and I don't allow myself to be drawn into commentary on individual cases.
Mr. Dunn.
Thank you, Mr. Speaker. Thank the Minister for the answer. How does the Minister then explain the fact that since devolution returned back in 2010, that inspectors have found out, going back to the November 24 report, they have found no meaningful progress in the transformation of our justice system?
Well, first of all, I don't recognise those comments. So when I look, for example, at the improvement in our prisons, there has been ample recognition of the significant improvements, both in terms of safety, security and rehabilitation activity within our prisons. There has been an acknowledgement of additional resources and investment and improvement in witness and victim experience in the court system. There has been acknowledgement of improvement in the time taken to deliver on some of the statutory functions of the department, particularly in issues such as access NI checks and others. There has been a significant improvement in terms of the work that's been done around tackling paramilitarism. So I think if the member wishes to cherry-pick comments out of an individual report, he may have to go somewhat further in his homework, identify the particular report and identify the area of criticism before I'm able to give him a comprehensive answer.
John Blair.
Thank you, Mr. Speaker. Can I ask the Minister to outline the challenges posed by the current system of community orders for children?
The current sentencing landscape for youth court disposals for children in Northern Ireland is very complex. There are 7 different types of communities orders available to the courts, and some of which they are rarely, if ever, used. Currently, the orders are provided through different pieces of legislation as well, some of which are more adult than child-oriented, and therefore they're supervised by 2 different organisations, Youth Justice Agency and Probation Board for Northern Ireland. Children can be subject to multiple and different orders at any one time with numerous requirements and under the supervision of 2 different justice agencies. We know from our discussions with children and families, with their parents and guardians, that this can be very difficult to understand and comply with, and the justice professionals who work in this sphere would agree. So that's why the strategic framework for youth justice contained a commitment to update and simplify the community sentencing framework for children.
Mr. Blair.
Mr. Speaker, I thank the Minister for that answer. Can the Minister give any outline of her plans to deliver a new single youth community order in that case?
Well, we are taking action to streamline, and the Department is currently holding a 12-week consultation, public consultation, on proposals to simplify sentencing framework by introducing a single flexible order which will be supervised by a single organisation in the Youth Justice Agency. The order, both its duration and requirements within it, will be tailored to the seriousness of the offence, the needs and best interests of the child, and the risk of harm and reoffending. It will be underpinned by restorative justice principles, which have been a successful feature of the youth justice system in Northern Ireland for the past 2 decades, and it will enable victims' views to be part of the process. I would encourage anyone who hasn't already engaged with the public consultation to do so.
Maurice Bradley.
Speaker, public safety seems to be the theme here this afternoon. So could I ask the Minister what assessment she has made for the public safety applications following real-term cuts to the policing budget, and whether she will bring forward a revised plan to protect frontline policing in general and neighbourhood policing in particular?
Well, the protection of neighbourhood policing is a matter for the Chief Constable, who has to live within his budget and make decisions about his priorities. It's not for me to tell him where he spends the money that the department gives him. It is, however, important to note that throughout the constraints that my department has been facing, PSNI has not only continued to receive 65% roughly of my department's budget, but has also been at the front of the queue when it has come to additional funding. So, for example, in the Executive's programme for government, we prioritised safer communities, and that's one of the areas where neighbourhood policing and other forms of policing are critically important. But it also recognises that there are other agencies and other departments, indeed, who have responsibility in that space, as it's a cross-executive target. We're now working on a proper strategy that will draw in every department who has a contribution to make. But of the £5 million that my department received in respect of community safety from the Executive in the anticipated June monitoring rounds, which have now been confirmed, 4.75 of that went to the PSNI.
Mr. Bradley.
Thank you, Mr. Speaker. Thank the Minister for her answer. But, Minister, I'm sure like other MLAs, no different from my constituency, response times are a real problem throughout the country, and I don't think, a lot of people out there don't think that we have the numbers to respond to keep this people in this country safe in their own homes and going about their own business. Can the Minister explain why there is a reduction in numbers, and how many numbers does she expect by 2026 compared to 2020 baseline?
Well, I can explain it, and it was because the previous Chief Constable decided not to go out to recruitment in a period when the Executive wasn't actually here, because he didn't feel that he had the confidence in terms of political leadership to be able to spend that money without the political cover to do so. So that's the reason why the figures fell quite dramatically, because as the member may recall, we actually increased police numbers from 7,000 to 7,100 during the last mandate when I was in office. So we've fallen quite far from that, and obviously with attrition year on year, that was quite significant. In terms of how we restore that, as you will be aware, there is a business case that we submitted to the Department of Finance. That has been approved with regard to value for money. There is still an issue about affordability, but that is not unusual with business cases in the Executive, and therefore I'm meeting with the Minister for Finance. I've already met with the Chief Constable, and we will work through the affordability issues. But I would say this, whilst I recognise that I would like to see higher numbers of PSNI officers available to Police Northern Ireland, if you compare Northern Ireland and the number of officers per head of population in Northern Ireland to other regions, we have a higher number of officers per head of population than other regions. And if you compare the number of crimes per head of population in Northern Ireland, we have a lower number of crimes in Northern Ireland than in other regions. So we need to be careful about the line between making a robust case for additional investment in policing, which I think is justified, and talking up a crisis of policing, which I believe is not helpful in terms of public confidence.
Michelle Guy.
Thank you, Mr. Speaker. Can I ask the Minister to outline her department's proposals for the recording and broadcasting of certain proceedings in the Crown Court and the Court of Appeal?
We have touched, as you will know, on a separate issue around the family courts, but I do believe that the broadcasting of certain court proceedings would be a positive step in terms of improving the public's right to see justice done. I'm proposing in consultation, which was published last Tuesday, that the following aspects of the Court of Appeal and Crown Court would be suitable for broadcast. That is the handing down of a judgment in the Court of Appeal, as well as the submissions of legal representatives and exchanges between legal representatives and the court, and judges making sentencing remarks in the Crown Court. Should there be support for the proposals, primary legislation will be required to provide the Department with the power to permit the recording and broadcasting of these aspects of the proceedings. Given the current legislative programme, this would be progressed in the next Assembly mandate, subject obviously to the incoming Minister and any new Executive agreeing to legislate in that regard.
Mrs. Guy.
Thank you, Minister. Can you outline the safeguards in these proposals to protect victims and witnesses and prevent undue prejudice?
Well, I would want to reassure members that I have no intentions of our courts being opened up to broadcasting in the way that, for example, has happened in the US, where they are a televisual spectacular as opposed to in the interests of justice. However, in our case, what we are talking about here is not a proposal which would allow the recording or filming of victims, witnesses, parties to proceeding, or jurors, or members of the public or court staff. The proposal we're consulting on is to give the Department a power to make secondary legislation, subject to the Lady Chief Justice's agreement, that would prescribe the proceedings and the particular aspects of those proceedings of which broadcasting would be permitted. Even in those circumstances, the decision on filming in a particular case would rest with the judge hearing that case, and recording by the broadcaster would have to be in accordance with the conditions imposed by that judge. Further, the judge would be able to direct that filming is not allowed in the interest of justice or to prevent undue prejudice. In considering any application from broadcasters to film, the judge would take into account any reporting restrictions in place to protect victims and witnesses. If filming takes place, it would be incumbent on the broadcaster not to breach those restrictions, including any entitlement there may be to anonymity.
Rick Murray.
Thank you, Mr. Speaker, and thank the Minister. Could I ask the Minister to provide an update on the development of the 2025-2030 victims and witnesses of crime strategy?
Yes, I'm very pleased to have recently launched a new draft Victims and Witnesses of Crime strategy for 2025 to 2030 for public consultation. It aims to ensure victims and witnesses are aware of their rights and are fully informed throughout their journey, and that services are tailored and responsive. We're trying to create confidence in our justice system by empowering and supporting all victims and witnesses with a trauma-informed approach.
Mr. Rick Murray.
Thank you, thank you, Minister. What is the Minister's assessment of the impact of the Commissioner Designate for Victims of Crime since her appointment in 2022?
3 years ago, I established a new role of Commissioner-designate for Victims of Crime for Northern Ireland, and the objective of the role was to give a voice to victims of crime, promote their rights under the Victims' Charter and raise their issues with government and criminal justice organisations. I was also keen that that Commissioner would drive forward system improvements for victims of crime and contribute to more cohesive, coordinated and victim-centred criminal justice approaches. I'm grateful to Geraldine Hanna for all that she's achieved during her time in office thus far, and when she has continued to identify and highlight issues that affect victims and affect real change for victims and witnesses within the system. The Commissioner-designate has completed and published her annual report and will produce her second annual report in the coming weeks. But in particular, I think the work she has done on victims' engagement in terms of research, policy influence, disclosure compliance, raising issues such as access to public galleries and courts, remote evidence centres, development of the statutory role for the Commissioner of Victims, as well as awareness raising, media and Victims' Charter compliance, have all made a very positive contribution to the justice system and to victims and witnesses in particular in Northern Ireland.
That brings to a conclusion questions to the Minister for Justice. We now move. Point of order.
Thank you, Mr. Speaker, for allowing the point of order. Can I apologise to you, Mr. Speaker, to the Minister and to the House for not being in my place when I was called for